and regulation. So in their wisdom, they decided to separate the two documents. So we now have the Police Act. Of course, the powers of the regulations emanates from the Police Act, but in their wisdom, they decided to separate it. So that, because if it could take 16 years to get us to have a Police Act, we can't tie that to a regulation. That's why they separated those documents, because the police regulation is supposed to be responsible for the operational running, day-to-day running of the Nigerian police force. So we do not want it, because if it's going to be tied to an act, it would mean it would have to go through the National Assembly and all of that, and that would take time. So to avoid all of those bottlenecks, which is a wise thing to do, it was separated. And that's why we don't have the act alongside the regulations in that sense. But now we have also, sat down again to look at the regulations, to update it or to make it be in sync with the act. But we're having challenges gazetting it, and that's why we're having this conversation. So I just wanted to explain why it was separated, and the need for the separation and the wisdom behind the separation, so that it can be reviewed periodically. Without because if it was tied to the act, it would mean that even if it's reviewed, they can't do anything. They will have to go through all the process of reviewing a law, an act of the National Assembly, which will take time. But because we wanted to, let's take it out so that it can be reviewed periodically to be in sync with international best practices. That's why it was separated. That speaks to accountability processes, that speaks to how police officers should behave and how they will be disciplined. But we have a regulation that is saying the exact opposite, that promotes or strengthens discriminatory practices, that gives, for sanctions, you see in the old regulation, you see things like 10 naira as as fine. So you would wonder what sort of that's really a cake. We need something modern or that is in sync with what the Police Act is saying. So we do not want these regulations or these provisions speaking different languages. Let them say the same thing. The Police Act is coming up. The MPF is saying we are a progressive institution that upholds human rights. We are gender neutral, but their regulations are saying the entire opposite. So we're saying they should speak the same language. And what that would also do for the police is, when we have troublesome people, what this can cause is that when we have troublesome, not necessarily troublesome people, but people who really know their rights, then we'll begin to have frivolous actions taken against the police. The police is already overwhelmed by the work on ground. They are short-staffed. They all hands needs to be on deck. But when they have to still, they will need to now keep dealing with court processes that have been filed against them because of what their regulation contains, or having to address the public. If you remember when this issue, it was a public issue, and then police will have to keep issuing statement upon statement to address it. We don't need that. So why not we have a regulation that already speaks to a progressive police, as the NPF, as the Police Act is, what the Police Act is already saying. So that's what we're saying. Let the regulations speak the same voice. Let it be in the same spirit as the Nigerian Police Act. And of course, that would improve accountability, because the spirit of the act is to foster accountability, is to build public trust. So the regulations need to speak to the spirit of that act. So we're saying the same. The stalling of the gazetting process has far-reaching implications. It hinders implementation of reforms intended to professionalize the police force and improve its relationship with the public. Moreover, the delay perpetuates the use of outdated regulations that fail to address current realities, undermining efforts to promote accountability and enhance public safety. What is the way forward? 1. Enhanced advocacy and engagement. Civil society and other stakeholders must intensify advocacy effort to ensure that the Ministry of Justice prioritizes the gazetting process. Strategic engagement with policy makers and leveraging public opinions can help achieve this goal. 2. Political will and leadership. The executive arm of government, particularly the Federal Ministry of Justice, must demonstrate the political will to advance the reform agenda. Clear directives and timelines for completing the gazetting process are necessary. 3. Strengthening institutional efficiency. Addressing the bureaucratic inefficiencies within the Federal Ministry of Justice is critical. Introducing digital processes and streamlining approval workflows would significantly reduce delays. 4. Monitoring and accountability mechanisms. Independent monitoring mechanisms should be established to track the progress of the gazetting process and hold relevant actors accountable for delays. In conclusion, the Nigerian Police Act 2020 aims to modernize policing in Nigeria, shifting from colonial practices to a framework centered on accountability, human rights, and community trust. While the Act outlines the progressive principles, the existing police regulations, a subsidiary legislation, remains outdated and contradictory to the new Act. This inconsistency hampers effective implementation. The reviewed police regulations, which involved collaboration between various stakeholders such as civil society organizations, the police, government ministries, must be expedited for gazetting. The Federal Ministry of Justice is urged to act promptly to finalize these regulations, ensuring that they align with the Police Act to effectively mitigate human rights violations, including gender discrimination, and enhance accountability within the Nigerian police force. The reform of the Nigerian police regulations is a cornerstone for building a modern, accountable, and community-centered police force. With substantial progress, while substantial progress has been made in drafting and revising the regulations, the stalling of the gazetting process by the Federal Ministry of Justice remains a major impediment. Addressing these challenges requires coordinated advocacy, strong political commitment, and enhanced institutional efficiency to ensure the long-awaited reforms becomes a reality. Thank you.